amendment before the House does not represent a wide-ranging departure from existing legislation. It does, however, have the potential to kickstart a wider debate on our sentencing policy and on our current prison policy. At a time when we face the reality of an already overcrowded prison system, and at a time when prison numbers continue to increase rather than decrease, when the operational procedures and conditions within the prisons themselves are suited more towards punishment rather than rehabilitation, and at a time when many people are of the opinion that we are not getting value for money, then I feel it is important that we debate the future of how we deal with crime in this state. And the recent decision by the Minister to review the future viability of Thornton Hall is to be welcomed, and I want to congratulate him on initiating such a review. And I feel it would be prudent if this review formed part of a wider debate on the future direction of our sentencing and prison policy. It is my belief that as a society, what we require is a complete reorientation of the penal system away from the prison and towards restorative justice within the community. We need to shift the prison from centre stage and devise more imaginative, humane, compassionate and effective ways to deal with petty offenders who form the bulk of those who are sent to prison each year. And the bill we are debating here today, coupled with this review on Thornton Hall, in my opinion, presents this House with the ideal opportunity to draw a line in the sand on a sentencing policy which has frustrated and continues to frustrate many members of the public. And for example, in my own constituency of Cork North Central, many people struggle to have any faith in the judicial system, which on one hand allowed a convicted heroin dealer caught with drugs to a street value of almost €200,000 get a 6-year suspended sentence, while on the other hand, the same justice system sent an individual who failed to pay a fishing fine to Cork prison for almost 1 week. And this is just one example of how the inconsistencies within the sentencing policy currently being implemented leads to a lack of trust and faith in our judiciary. And it is for this reason I urge the Minister, in the context of the review in relation to Thornton Hall, the passage of this piece of legislation and the introduction of all future justice legislation, to look at what works, what is in the best interests of society, of those working within the prison system, the offender, and most importantly, what will give the taxpayer the best value for money. For instance, unless proper drug and rehabilitative supports in prisons are resourced, alongside educational facilities, and other steps are taken to address recidivism, we will simply be ignoring what has been proven internationally to work. And I think it is time that we all acknowledge that creating a couple of hundred extra cells is not a sufficient mechanism to tackling the growing prison crisis we face. What is needed is a well-thought-out and adequately resourced strategy to deal with the increasing rates of imprisonment. The increase in prison numbers, which have led to a prison system bursting at the seams and has contributed to the creation of serious health and safety issues within the prisons themselves, as well as increasing the dangers faced not only by prisoners but by the staff working within our prisons. Therefore, it is imperative that all future justice policy needs to be very mindful of the causal factors which are helping feed these increases and address them accordingly. Factors such as poverty, embedded disadvantage, inequality and addiction. And while the number of prisoners have grown through a variety of issues such as those just mentioned, we should also recognise that an increase in the use of custodial sentences alongside a complex asylum and immigration system and the enactment of criminal justice legislation since 2000 have been contributory factors. The move towards the provision of mandatory minimum sentences for an expanding number of offences is a questionable policy. Mandatory sentences have been proven internationally to not only swell prison numbers, but they have been proven that they have little or no impact on crime trends. Over the past decade, we have seen a slow but progressive increase in the prison population, while also experiencing a sharp increase in the daily average number of persons in custody. And what this appears to indicate is a slow increase in the prison numbers, exacerbated by an increase in prison sentences for minor offences but being held back by overcrowding. It was reported that in April 2010, overcrowding in the Irish prison system had reached record highs, and that as a consequence more than 800 inmates were freed on the early release programme, as there was an insufficient amount of space to contain them, and the vast majority of whom were serving sentences of less than 12 months. We should also note that international research indicates that short prison sentences act neither as a deterrent nor as a means of rehabilitating the offender. And this goes to the very heart of the debate, in my opinion. Do we as a state view prison sentences as a tool to punish or as an opportunity to rehabilitate offenders? And there is no question in my mind that the relatively limited duration of many sentences handed down by our courts, especially those sentences of 12 months and less, means that there is little or no scope to provide people with rehabilitation services. And the same question can be asked of the community service orders. Do we view them as a means to punish or rehabilitate? And I think the answer is dictated by the model that Ireland employs. The application of the community service order scheme differs from country to country, and the outcome depends on the type of model used. For example, some community service models focus on educating offenders about the impact their crime has on victims, the wider community, and indeed on the offender themselves. Some models focus on training offenders in useful skills, while others involve more menial tasks, and Ireland, in my opinion, falls into the latter category. The Probation Service, in its 2009 annual report, describes the work involved in community service order scheme to include landscaping, painting, decorating, repairs and renovation, work support to community centres, sports clubs and schools, among many other challenging schemes in local communities. In my opinion, the imposition of community service orders must be twofold. Firstly, they must be about accountability, and secondly, they should be about rehabilitation. Those who commit crime must be held accountable for their actions, but as a society, I also feel we have a responsibility to ensure that the offender gets the opportunity to access proper training and education so they do not become repeat offenders. And I know that there will be some people out there who will question this approach. They will state that a person who commits a crime should do the time and that the state should not be spending valuable resources on trying to rehabilitate them. And while in their own minds this may be a valid option to them, it is not one which I share. I believe a judicial system which is only geared towards punishment and does not recognise the benefits of rehabilitation is counterproductive. And any legislation which moves our justice system further towards rehabilitation and accountability rather than just being focused on punishment is to be welcomed. And this bill does just that, in my opinion. This bill sets out when a court shall or when a court may consider a community service order where a prison sentence would otherwise have been enforced. This bill does not create any new sentence which does not already exist within Irish law. Community service orders are already a tool which is open to the judiciary when dealing with convictions, and I think that is a very important fact to be highlighted. At present, the judiciary are free to disregard community service orders as an option to imprisonment. This amendment proposes to change this situation by making it a requirement to consider community service orders as an alternative to imprisonment for minor offences. In recent years, there has been an increase in imprisonments for minor offences which have had far-reaching implications for society in terms of prison overcrowding, prison conditions and the ability to rehabilitate offenders, in addition to increasing public expenditure levels. All of the data available to us on prison numbers appear to show that a large number of imprisonments are for minor offences and that these numbers are on the increase. A recent report by the Irish Prison Service shows that between 2004 and 2009, prison sentences of between 6 and 12 months increased by more than 50%. Sentences between 3 and 6 months increased by almost 60%, while sentences of less than 3 months increased by a staggering 188%. In 2009, there were 10,865 prison sentences imposed by our courts, and of this, 9,216, or 85%, were for 12 months and less. And while speaking to people regarding this proposed amendment, there were two questions which repeatedly came up. The first is the type of crime those people serving sentences of less than 12 months had committed. To answer the question, we can look to the Irish Prison Service, which recently produced a snapshot of the type of offenders who were serving prison sentences of 12 months or less. The snapshot was conducted on the 4th of December 2009, and it revealed that on this particular day there were 467 people in prison serving sentences of less than 12 months. 40% were for offences against property without violence, 78 or 17% were for road traffic offences, 58 or 12% were for offences against a person, and 1% were for offences against property with violence. More recent data shows that fine defaulters accounted for more than 3,300 committals to our prison system in the first 10 months of 2010. Now, this is a statistic which is very troubling. It is particularly worrying to realise that people who fail to pay small fines for whatever reason, people whose offending, in my opinion, should not be serious enough to warrant a custodial sentence in the first place, are ending up in our prison system. And as they serve short periods in custody, fine defaulters account for only 1 or 2% of the prison population on any given day, therefore leading to a distortion of the figures. Working on these statistics that I've just mentioned, there is a concern among the wider public that offenders who have committed crimes of a certain nature could become the beneficiaries of this amendment. And in fairness, there is a genuine concern when one considers that those who committed crimes of assault with violence, drug-related crimes, crimes of a sexual nature, or of offences against property with violence make up 23% of those serving 12 months or less on the particular day that the snapshot was taken, the 4th of December. Now, in order to allay these fears, we must look at Section 3B and Section 4 of the bill, which deals with these concerns adequately, in my opinion. Section 3.1b provides that where a court is considering the making of a community service order in lieu of a prison sentence, it has to give notice to the probation service. It should also be noted that this bill seeks to improve the existing legislation and make the procedure and system of making such probation reports more standardised, providing a time limit for efficiency and a certainty within the process, and this is reflected in Section 3.1c, which states that there will be a requirement on the probation service to act in a speedy manner when a judge indicates that he or she is considering a community service order in lieu of a prison sentence. Section 3.1d states that an assessment report by a probation officer should be given within 28 days of court notice to the probation service, but in exceptional circumstances this time period can be extended where there is, quote, good reason for doing so and would be in the best interest of justice to do so, end quote. Section 4.1a states that a court shall not make a community service order unless the following conditions have been complied with. 1. Having considered the offender's circumstances. 2. Having considered the assessment report prepared by the probation officer pursuant to the request under Section 3.1b. And 3. Where the court thinks it necessary, having heard evidence from such an officer that the offender is a suitable person to perform work under such an order and that arrangements can be made for him or her to perform such work. Section 4.1b states that the offender has consented to the making of such an order. And finally, under Section 4.1c, which states that under this Act, the Court may review the order on the application of either the offender or a relevant officer. And I think it's only fair to say, Minister, that these proposed changes will be important additions for improving public confidence in our sentencing policy, especially in regard to the use of community service orders.
Of course, you've just you're sharing time.
Yes.
You have about seconds left if to the Deputy Ellison.
I'll be taking about 20 odd.
Okay, that's fine.
Okay,
thank you, Deputy.
Thanks, Lance. The second question that people repeatedly asked me while discussing this proposed amendment, Minister, was whether this legislation will represent good value for money. And this should come as no surprise to us in the current economic position we find ourselves in. People not only want better legislation, they want legislation that represents good value for money. Now, while the explanatory memorandum to the bill states that there will be no additional costs in implementing the bill and that the existing resources of the probation service will meet the expected increase in community service orders, it is very important to recognise that the introduction and passing of this amendment will inevitably lead to greater demands being placed on an already overstretched probation service, despite the attempts to address this issue in Section 2. The probation service must continue to be adequately resourced so that this increased volume of community service orders can be effectively administered. That will be a challenge in the current economic climate, but is one which this government cannot afford to cut corners on. Failure to adequately fund the probation service will undo everything that this proposed amendment sets out to achieve. But undoubtedly, an increased use of community service orders will lead to a savings in the overall scheme of things. The value for money analysis of the community service order scheme carried out by the Department of Justice and Law Reform in 2009 demonstrated that the use of community service in lieu of prison would provide significant savings. The cost per community service order is estimated at approximately just over €4,200 per offender, while the alternative costs of imprisonment are estimated to amount to just under $28,000 per offender. But the state should not see these savings as a means to an end, but as an opportunity to reinvest in crime prevention measures such as the juvenile diversion programme, as well as increasing funding to the probation service to deal with the added number of reports this bill will inevitably create. But apart from the financial benefits the community service order scheme will offer, there are far more important factors to be considered while we debate this bill. As I outlined at the beginning of my speech, the whole debate on whether community service orders help reduce offending rates is one which should be central to this bill. Again, quoting the Probation Service report of 2009, in which it looks at the features and benefits associated with the community service order scheme, we can see the social advantages of such a scheme. The data was collected by 29 senior probation officers who were asked to identify the main benefits associated with the scheme. And from their responses, we can see that the benefits include the offender remaining in work or education, remaining part of both their family and the community. The scheme can provide an opportunity to learn new skills, as well as providing a means for the offender to make amends for their action, which is an important point, all of which will have a positive effect on the community and the offender. However, I do feel there is additional room for improvement in the proposed bill, and maybe these are improvements which can be investigated in more detail as it progresses through the House. For instance, the presumption against imprisonment in Section 3.1a should be strengthened by requiring the sentencing judge to not only consider imposing a community service order in lieu of imprisonment for a qualifying sentence, but by obliging him or her to give their written reasons behind the decision to imprison the individual before the courts rather than impose a community service order. And can I also say that while I was reading this particular section of the bill, I was struck by one glaring omission whose inclusion, I feel, should be given serious consideration. Every crime has a victim, and the effect that that crime committed has on the victim should and must be a central consideration when a judge is leaning towards the imposition of a community service order rather than a prison sentence. And we need to consider the inclusion of victim impact statements as part of the process in determining whether someone is suitable for a CSO. But in conclusion, it is fair to say that the community service order scheme, particularly for minor offences, can have many advantages. For society, it can be more cost-effective than prison. For the offender, it may mean the difference between a life of crime or a wake-up call. And for the community, it provides a tangible benefit through works and services which may otherwise not be undertaken. And importantly, it can benefit society through reducing recidivism rates among offenders. And for all of these reasons, I welcome the proposed bill, but with the caveat that the suggestions made earlier in relation to the victim impact statements and redirecting any savings accrued by the implementation of the legislation be reinvested into crime prevention and instigated as it progresses through the House. Thank you.